Good evening, sir. A warm welcome to everyone and good evening to everyone. I'll request Advocate Vaishali Tikle to give a short introduction about Avhad, sir.
Thank you, Shraddha. Good evening, sir.
Yeah, good evening.
Good evening, all connected for this 9th webinar series. I'm Advocate Vaishali Tikle and I welcome you all for today's session, which is on constitutional law. I take it's my privilege to introduce today's dynamic speaker, Advocate Arvind Avhad. Sir belongs to a family of lawyers. He has completed his BSL LLB degree from Pune University and has accomplished the LLB degree with successful rank from Cardiff University, United Kingdom. He has been practicing before the Supreme Court of India since last many years and has successfully represented the state government of Maharashtra in various cases. He has been appointed as standing counsel for many institutions, governmental organizations, etc. Sir has also authored, just like his father, myriad books. To name some, the Indian legal and constitutional history, and he has co-authored law books titled as Handbook for Judicial Examination. Sir has delivered in many law colleges and bar associations, including the Judicial Academy at Uttan, in the lecture series arranged by Bar Council of Maharashtra and Goa. We welcome you, sir. And on this note, I will hand over the microphone to Sir to enlighten us on the constitutional law. So over to you.
Yeah. Shall we start the lecture? Friends, I am indeed very glad that I got an opportunity to express myself before you all to this webinar. I am indeed very new, and this happens to be my first or second time that I am giving a lecture by way of internet. Because I am used to see the faces of the audience, and as for the faces and the gestures, I change and I extend and I decrease my topic. But now I am not able to see you, but at least you are able to see and you are able to hear me. That's a glad moment. I am indeed thankful that Advocate Vaishali Tikle, Advocate Suvarna Naik, Advocate Dalvi Sardhaji, all these three could make this a successful attempt, whereby we are now entering into a new era, whereby you all are sitting in your houses and I am sitting in my office and I am delivering a lecture. Friends, indeed, it's a glad moment that we are utilizing this free time to gain and enrich our knowledge. The topic that has been assigned to me is as to the constitutional law, but I would just elaborate. The topic happens to be various cases of Supreme Court, landmark judgments of Supreme Court that have given shape to the Constitution. Landmark judgments of Supreme Court that have given shape to the Constitution happens to be our topic. As we all are seeing, I will be making use of Hindi and English in my lecture. I will start by one poem of a famous poet. He is a Hindi poet, and he has said in his poem, Sumitra Nandan Pant, he says that जाग रहा है कौन धनुर्धर जबकि भुवन भर सोता है, जाग रहा है कौन धनुर्धर जबकि भुवन भर सोता है, भोगी कुसुमा योगी सा बना दृष्टिगत होता है, ये कौन सा धन है जिसकी रक्षा में इसका तन है, मन है, जीवन है, मृत्यु लोक मालिन्य मेटने स्वामी संग जो आई है, तीन लोक की लक्ष्मी ने आज ये कुटिया अपनाई. Sumitra Nandan Pant, he is describing that Ram and Sita are resting in their hut and Lakshman is very vigilant. जाग रहा है कौन धनुर्धर, that is Lakshman. Now again we will recite the poem. इस कविता में से आप लक्ष्मण को हटा दीजिए और इस कविता में सोए हुए कुटिया में सीता और राम को हटा दीजिए. लक्ष्मण की जगह आप सुप्रीम कोर्ट को अपने ध्यान में, अपने जहन में डालिए और कुटिया की जगह आप इंडियन कॉन्स्टिट्यूशन को अपने जहन में आप उसको इमेजिन कीजिए. तो जाग रहा है कौन धनुर्धर मतलब सुप्रीम कोर्ट, जबकि भुवन बरस होता है मतलब रात को 3-3 बजे भी सुप्रीम कोर्ट के जजेस उठते हैं, सुप्रीम कोर्ट खोलते हैं और न्यायदान करने का काम करते हैं. जाग रहा है कौन धनुर्धर जबकि भुवन भर सोता है, भोगी कुसुमा योगी सा। एक योगी के जैसे सुप्रीम कोर्ट की हरकत है, भोगी कुसुमा योगी सा बना दृष्टिगत होता है। और कभी आगे पूछता है, इस कुटिया में, इस कॉन्स्टिट्यूशन में ऐसी क्या बात है, इस कुटिया में कौन सा धन है, इस कुटिया में कौन सा धन है जिसकी रक्षा में इसका तन है मन है जीवन है। इस कुटिया कॉन्स्टिट्यूशन में ऐसी कौन सी बात छुपी हुई है जिसकी रक्षा करने में सुप्रीम कोर्ट ने अपनी सारी जान लगा दी है। इसीलिए कवि कहते हैं कि मृत्यु लोक मालिन्य मेटने। आज भारत में जो मालिन्य, मालिन्य मतलब भारत में आई हुई जो इनजस्टिस की अवस्था थी उसको समेटने के लिए, उसको मिटाने के लिए, मृत्यु लोक का मालिन्य मिटाने के लिए स्वामी संघ जो आई है, तीनों लोक की लक्ष्मी ने आज ये कुटिया अपनाई है। इस इंडियन कॉन्स्टिट्यूशन को, इंडिया में इस संविधान को लाने के पीछे जो मोटिव था वो यही था कि अनेक वर्षों से भारत में जो अस्पृश्यता, अनटचेबिलिटी थी, अनेक वर्षों में जो सोशल डिस्टेंसिंग भारत में फॉलो किया जाता था, अनेक वर्षों से भारत में जो इनइक्वल ट्रीटमेंट दी जाती थी, इन सबको समेटने के लिए और सबको एक दर्जे पे लाने के लिए कॉन्स्टिट्यूशन की निर्मित हुई थी। और कॉन्स्टिट्यूशन की निगरानी करने का काम सुप्रीम कोर्ट को दिया था। दैट हैपेंस टू बी द रोल ऑफ सुप्रीम कोर्ट, द गार्डियन ऑफ द कॉन्स्टिट्यूशन। Friends, we all know that in India we have a written constitution. In England, in United Kingdom, they don't have a written constitution. That is called as Magna Carta. In England, they don't have a written constitution. It is jokingly said that the Parliament of United Kingdoms can do and undo anything except converting a man to a woman and a woman to a man. If a law is passed by the Parliament of United Kingdoms to kill all the blue-eyed babies, that will be a valid law in UK. Because in UK, Parliament happens to be the supreme authority, the supreme body. And when Parliament is supreme, then, and when there is no constitution to act, then there is no doctrine of judicial review. But on the other hand, in America, we have the doctrine of judicial review because there is a written constitution. And in the historic case of Marbury versus Madison, Justice Marshall had pronounced that all the actions of the state, of the government, of the state machinery shall be within the four walls, within the dictate of the constitution, and the responsibility whether the activities are correctly conducted within the four walls of the constitution, that guardianship role will be with the Supreme Court, with the judiciary. It is said that Indian constitution is just like word mother. If you are told to write word mother on a piece of paper, they are just 6 dead letters. But if you are in real life told to exactly analyze what exactly word mother means, then n number of experiences will fall short to explain the real meaning of word mother. Same is with Indian Constitution. Indian Constitution consists of 395 articles. But these 395 articles are, friends, just dead letters of the statute. They have no meaning unless the judges they put life in these dead letters. Unless the judges they don't pronounce by way of their judgments, there is no life into these articles. They are mere dead articles. Just like writing word mother on a piece of paper is of no use. Similarly, reading the Constitution as it is carries no meaning unless we understand the judgments of Supreme Court that have poured life in the Constitution. Jnaneshwara, when he wrote Jnaneshwari and when he was speaking about Bhagavad Gita, he says that the book which is capable of changing its meaning as per the changing times will only survive in the coming era. जो किताब अपने आप को बदलते हुई परिस्थिति में खुद को बदल सकती है और आए हुए काल में अपने आप को नया अर्थ प्रदान करने का काम कर सकती है, वही किताब चिरकाल टिक सकती है, वही किताब अनेक वर्षों तक, अनेक सालों तक लोगों की न्याय तृष्णा को तृप्त कर सकती है. Same is with the Indian Constitution. Indian Constitution merely carries no meaning unless the life which it has gained by way of various judgments of the Constitution is understood by us. Friends, as we know, Article 21. Article 21 are two mere dead letters of the Constitution. No person shall be deprived of the right to life and personal liberty except in accordance with the procedure established by Article 21. These two articles are dead articles. They carry no meaning unless we understand what the Supreme Court says in numerous cases right from the case of Khadak Singh, when Supreme Court says the same two lines. In Khadak Singh's case, they mean right to life includes right to privacy. The same case in case of Ravikant Patil, right to life means right to dignity. The same case of Supreme Court, Hussainara Khatun, the same Supreme Court says right to life means speedy justice. Right to life in Permanent Katara means right as to health. Right to life is the right to have health medical facilities. Friends, there are numerous meanings given to right to life, and the day is not far in today's era of social distancing when we are meeting together by way of internet and this cyberspace. Right to access internet can also become a fundamental right. So as the need of the society changes, Supreme Court interprets the same articles of the Constitution and is capable of giving new meanings to these two articles, to these two sentences, or any article in the Constitution is provided is enlightened by Supreme Court. That is what is the beauty of Indian judiciary. That is what is the beauty of Indian Supreme Court or Indian judiciary, we must say. Many times, as I was saying, that right to life has a number of a catalog of meanings that is given by Supreme Court. If you come to Supreme Court, the library of Supreme Court is full of books where these two sentences as to right to life is given a well-defined meaning, is given an elaborated meaning, expanded meaning, whereby at least 200 books are there in Supreme Court's library which define and which entail what exactly is the meaning of these two sentences. Life is given to dead letters of the Constitution by judgments of Supreme Court, and meaning of the Constitution is changed as per the changing times, changing need of the society. Starting with this, friends, we should now take into consideration that, as I was saying, that Supreme Court by way of various judgments has given numerous meanings to right to life. Question may arise as a lawyer in our mind that whether Supreme Court makes the law or Supreme Court declares the law. We have seen in the case of Vishakha versus State of Rajasthan, there was no parliamentary law in existence to protect, preserve the rights of our female sisters, female Indian citizens who were working at their workplaces against sexual harassment of these females. There was no law in existence. Supreme Court had to step in and Supreme Court had to frame guidelines. So in absence of parliamentary law, Supreme Court by way of its judgment had to frame the guidelines, and those guidelines were followed all over India. Question may arise in your mind whether Supreme Court makes the law or Supreme Court declares the law. If you see MC Mehta's case, a whole new plethora of cases, a whole new subject of environmental law was developed only by the person MC Mehta, where Supreme Court interfered in his petitions, and in MC Mehta's case, Supreme Court said right to life includes right as to environment. Right to life in the case of Ganga, the MC Mehta versus Union of India, into bracket the Ganga case. We all know that Bhagiratha, by way of Bhagirath Prayatna, he brought the holy Ganga, which was flowing in the heavens, to the earth. और ये गंगा जो भगीरथ ने धरती पे लाई और जो पापियों का पाप, उनका विनाश, पापियों के पाप का विनाश करने के लिए जो गंगा कटिबद्ध थी, लोगों के बढ़ते हुए जो प्रोग्रेस था, लोगों के बढ़ते हुए प्रोग्रेस के कारण यही गंगा अपवित्र अशुद्ध हो गई, और फिर लोगों के सामने ये सवाल था, ये प्रश्न था कि दूसरों को पवित्र करने वाली गंगा को आखिरकार पवित्र कौन करेगा? That Ganga which is capable of purifying others, now who will purify that sacred Ganga? And then Supreme Court had to step in. There was no law to prevent or no law to preclude water pollution at that time in India, and Supreme Court by way of judgment had to prevent the pollution of river Ganga. If you come to Delhi, friends, you will see that all the public transport in Delhi is on CNG. The public transport, the buses which run in Delhi are on CNG. They are not on petrol, neither on diesel. And the reason is not any law passed by the Delhi government, but merely because of the judgment of Supreme Court. Capital of India was also the capital of air pollution in the world. And the air in Delhi was so obnoxious that people were unable to breathe in the air. Supreme Court had to step in, pass the judgment in MC Mehta versus Union of India, into bracket the CNG case, where all the public transport in India, in Delhi, was made to run on CNG. So friends, we may be engulfed with the question. We may be confused whether Supreme Court now is making the law or whether Supreme Court is declaring the law. In absence of parliamentary law, Vishaka's case, Supreme Court frames guidelines. In absence of air pollution, water pollution, Supreme Court comes in between, interferes in MC Mehta's case and frames guidelines. Those guidelines are followed as if they are law made by the parliament. So we have to ask ourselves, clarify ourselves whether Supreme Court is making or Supreme Court is declaring the law. And as lawyers, as constitutional students of constitution, we should be very much aware, we must be very much clear, and we must have clarity in the mind that Supreme Court never makes law. Lawmaking is the responsibility, lawmaking is the duty, I would say rather, of the parliament. Supreme Court only declares the law. What is unsaid, what is hidden, that meaning therefore thereof is unfolded by Supreme Court. What is unsaid by the Constitution, what is hidden in the Constitution, that meaning is just elaborated. Supreme Court never makes law, Supreme Court only declares the law. Lawmaking is the function of Parliament. Lawmaking is the duty of the Parliament. Parliament cannot abdicate by that duty, but whenever Parliament falls short, Supreme Court is then capable of declaring what is unsaid in the Constitution, and right meaning is given by Supreme Court. And whenever the duty of the Indian Constitution and the duty why Indian Supreme Court or Indian Judiciary still carries importance in the minds, why Indian Judiciary is still considered, has gained confidence in the minds of Indian public, is the reason is that Indian Supreme Court corrects its wrong decisions. Whenever Indian Supreme Court feels that any of the judgment given by itself is wrong, or when the Supreme Court feels that it has exceeded, it has transgressed the line of distinction, that Lakshman Resha between the Parliament and the Judiciary, whenever the Supreme Court feels that we are crossing that line, Supreme Court clarifies, Supreme Court rectifies, Supreme Court cures such judgments. And whenever the Supreme Court has transgressed, whenever Supreme Court has excessed, has caused excesses in its judgment, and whenever Supreme Court has found that in fact it is doing the duty of the Parliament, Supreme Court has cured those judgments. Supreme Court has cured itself, has rectified itself. आजकल टीवी पे महाभारत का शो चल रहा है. महाभारत में आने वाले शो में आप देखोगे, जब दुर्योधन की दोनों टांगे कटी हुई होती है और रणभूमि में दुर्योधन पड़ा होता है, उसको मिलने के लिए कृष्ण जाते हैं. तो कृष्ण से दुर्योधन बड़े चाव से पूछते हैं कि कृष्ण, आप मुझे एक बात बताइए कि आपसे दुगनी सेना मेरे पास थी, आपसे दुगने बलवान योद्धा मेरे पास थे, पर फिर भी आज मेरी ऐसी अवस्था क्यों हो गई कि ऐसा मैं जो पंगु अवस्था में आज यहाँ पे पड़ा हुआ हूँ, दोनों मेरी टांगे टूटी हुई है, ये अपंगत्व मुझे आने की क्या वजह है? तो कृष्ण बड़ा मार्मिक जवाब दुर्योधन को देते हैं, और ये जवाब इंडियन सुप्रीम कोर्ट के सारे जजेस को भी मालूम है. इसीलिए इंडियन सुप्रीम कोर्ट आज भी लोगों के मन में कॉन्फिडेंस पैदा करता है, और कॉन्फिडेंटली लोग इंडियन सुप्रीम कोर्ट की तरफ एक इंटीग्रिटी की नजर से सुप्रीम कोर्ट की तरफ देखते हैं. कृष्ण ने दुर्योधन को यह कहा था कि त्वम जानम अधर्मम न चले प्रवृत्तम. धर्म अधर्म क्या है तुम भली भांति जानते हो, अच्छी तरह जानते हो. त्वम जानम अधर्मम न चले प्रवृत्तम, इसका मतलब यह है कि तुम धर्म अधर्म अच्छी तरीके से जानते हो, पर की हुई गलती सुधारने की जो मंशा है, जो मन का बड़प्पन है, वो तुम्हारे पास नहीं है. वो ह्यूमिलिटी, वो हम्बलनेस, वो तुम्हारे पास नहीं है. तुम बड़े एडामेंट हो, एरोगेंट हो, यही तुम्हारे विनाश का कारण है. मित्रों, भारतीय सुप्रीम कोर्ट इस बारे में बड़ा ही सजग है, बड़ा जागरूक है. और जब सुप्रीम कोर्ट को यह लगता है कि हम पार्लियामेंट का काम कर रहे हैं, हम अपनी लक्ष्मण रेखा को लांघ रहे हैं, तब तक सुप्रीम कोर्ट ने अपनी ये गलती मानी हुई है और सुप्रीम कोर्ट ने अपनी ये गलती सुधारी हुई है. जुडिशियल एक्टिविज्म के चलते जब भी सुप्रीम कोर्ट को ये महसूस हुआ कि हम पार्लियामेंट का काम कर रहे हैं, तो सुप्रीम कोर्ट ने अपनी ये गलती मानी और अपनी की हुई गलती को सुधारा भी है. वो कौन से जजमेंट्स, वो भी अभी हम देखेंगे. इसमें सबसे पहला जजमेंट है मिलिंद का. द स्टेट ऑफ महाराष्ट्र वर्सेस डॉक्टर मिलिंद. Friends, the facts of the case are very interesting. The facts of the case are very interesting, whereby I would like to tell, Milind was a candidate who was intending to go for his medical career, and that time this Milind He belonged to a scheduled tribe community. He was from some area in Maharashtra, that is Vidarbha, and he was alleging. Facts of the case are to be noted very minutely, and you need to be very full of years in noting the facts. The facts are very interesting. This Milian, he was in 12th standard. He wanted to go for medical exam. He wanted to appear in medical exams and he wanted to become a doctor. He was with the contention before the Nagpur High Court by filing a writ petition under Article 226 that, look, I, Mr. Milian, I don't belong to scheduled tribe community. But taking into consideration the food habits, the worship habits, the cultural habits, my traits, the characteristics of my community and the scheduled tribe community, Halba Koshti scheduled tribe community, these two communities, they bear similarity. Milind was very clear that he does not belong to scheduled tribe. He was saying that my community is not scheduled tribe, but it is having similarity with that community which is being entrusted with the features of scheduled tribe community. So I also want to gain the benefits of reservation, apply Article 14 equality principle. Not only me, but my entire community should be given benefit as belonging to scheduled tribe. Is the fact clear? He was saying that Parliament has not notified me as a scheduled tribe, but my habits and the scheduled tribe community habits are quite similar. Now you give me and my community benefit of being a scheduled tribe. And High Court of Nagpur bench, High Court Bombay, that erroneously said that yes, taking into consideration the factual aspects which are shown by Mr. Milian, now we give him and his community benefits of being a scheduled tribe community. And therefore, not only Milind, his entire community got the benefit. He took the benefit of being a scheduled tribe. He became doctor. And after 15 years, the matter was challenged by state of Maharashtra in Supreme Court. And then the state of Maharashtra versus Dr. Milind, the case, Supreme Court said that giving or taking away the benefit of reservation cannot be done by the judges, cannot be done by the judiciary by way of judicial judgments. Giving or conferring benefits of reservation to any caste is the responsibility of the parliament, and that can be done by the law of parliament alone, not by judicial judgment. This was a restriction, a self-imposed restriction placed by the judiciary upon itself. Under the garb of judicial activism, we should not trespass into, we should not venture into the area of parliament. Second important case, P. Ramchandra Rao versus Karnataka. Friends, we all know there is a hue and cry all over India that justice delayed is justice denied. Cases are seen to be pending all over India. Father institutes a suit and son will get the benefit thereof is jokingly said in India. The same hue and cry and the same jokes which were made against the judiciary was heard by Supreme Court, and Supreme Court in the landmark case, of Rajdev Sharma said that all the criminal cases, note the facts very minutely. What Supreme Court said, because justice delayed was justice denied, and the judicial mechanism is delaying unnecessarily or because of the workload. So Supreme Court had to interfere, and Supreme Court passed a judgment that in all the criminal cases, whereby there is an allegation against the accused, and charge has been framed. He is accused, offense is alleged against him, charges are framed, but trial has not started, and 2 years have commenced. Charge framed, trial not started, 2 years have elapsed. All these kinds of accused will now be let scot free. They will be acquitted, they will be discharged. Criminal case, trial has not commenced. There is accused, allegation against him as to committing a crime is there. 2 years have elapsed, but trial has not commenced. So they all will be discharged, they all will be acquitted. And then by way of this, it was found that many, really the people again, who had committed crime, they also were now let scot free. They were also now discharged and acquitted. And again, there was a huge hue and cry all over India, whereby genuine cases, whereby really the people who had committed the crime, in those cases also there was unnecessary acquittal, and Supreme Court in the case of P. Ramchandra Rao had to step in, and Supreme Court then clarified that acquitting or convicting the accused is done by way of CRPC. And Supreme Court, by way of judicial judgment, cannot reduce, cannot take away that time which is prescribed by the law that is passed by the Parliament. So, accused person is let scot-free by way of judgment, and blanket judgment is passed by Supreme Court. Supreme Court understood the mistake. Supreme Court understood that Lakshman Resha Supreme Court has crossed, and Supreme Court rectified. Supreme Court clarified its mistake. It corrected its mistake, and Supreme Court said that such kind of acquittal or discharge can be done by Parliament by passing a law and law alone, and that too by necessary amendment in CRPC. That cannot be done by any judgment, any blanket judgment of Supreme Court. So this is what is the beauty of Indian Supreme Court, whereby it declares the law, and whenever Supreme Court feels that it is now taking up the responsibility of the Parliament of making the law, Supreme Court stops itself. Supreme Court places a restriction upon itself. Supreme Court rectifies its. Supreme Court cures its. Supreme Court corrects its own judgments, and Supreme Court is hence respected, and Supreme Court is adored in India, still is looked upon with confidence because of this attitude of Supreme Court, whereby it clarifies, it accepts with large heart its own mistake, and it clarifies and cures its mistakes. Friends, many times it is said that in India we have independent judiciary, and Indian judiciary is said to be independent. So the next aspect of our discussion is independent judiciary in India. As it was narrated at the starting of the lecture, that I have completed my master's LLM from Cardiff University in United Kingdoms. What I found in United Kingdoms is that in United Kingdoms there is no independent judiciary. As I in the beginning only commenced with the lecture, that in UK they don't have a written constitution. Similarly, in United Kingdoms, they, friends, do not have independent judiciary. The chief of the judicial unit in United Kingdoms is called as Lord Chancellor. Lord Chancellor, in the morning he gets up and he goes and sits on the chair of Ravi Shankar Prasad, Law Minister. After finishing the work as a law minister, the same Lord Chancellor gets up from the chair of law minister and goes and sits on the chair of Speaker of Lok Sabha, Om Birla. After finishing the work of Om Birla, the same Lord Chancellor goes and sits on the chair of Justice Bobde. So the same Lord Chancellor is combined with three functions. Lord Chancellor in England is also the Speaker of the Lok Sabha. He is the Chief Justice of England, the head of the judiciary, and he is also a law minister. The House of Lords, highest court in United Kingdoms, friends, you will be amazed, astonished to know that the House of Lords in United Kingdoms, where judges they sit along with parliamentarians. आप इमेजिन कीजिए अगर हमारे यहाँ पे जस्टिस बोबडे या सुप्रीम कोर्ट जजेस के साथ अगर कानीमोजी ए राजा ऐसे अगर एक्यूज्ड आके मेंबर ऑफ पार्लियामेंट बैठने लगे तो किस किस्म का न्याय होगा. But in England, that is a factual scenario whereby the judges are accompanied by members of parliament. But in India, we have independent judiciary. We have independent judiciary. Why Indian taking into consideration the scenario in India, why independent judiciary is needed? Friends, if you ask a mother a question that out of the 3 kids, Indian constitution has 3 kids, and say a mother is having 3 kids. If a mother is asked a question, out of the 3 kids, which kid do you like the most? Any mother will have affinity equally to all the 3 kids, but it will have more affinity. She will have more affinity to that kid which is the weakest. Which is weakest amongst the 3, mother will have more affinity. Indian constitution also has 3 kids. One is the parliament, one is the executive, that is the prime minister, and one is the judiciary. Out of the 3 kids of the constitution, judiciary is the weakest. It is neither with a sword nor with a purse, but mere judgment. It is neither with a sword. Sword means the police machinery, the military machinery, that is with the executives, with the prime minister and the council of ministers. Purse means the budget sanctioning authority. That purse, the money sanctioning authority, is with the parliament. So parliament is having money, controlling the monetary aspect. The executives are controlling the military and the police force actions. So judiciary is with mere judgment. Therefore, judiciary is the weakest organ, and judiciary is to be protected. Was fed by the Indian constitutional makers from the beginning itself, and therefore they have made all the attempts to keep Indian judiciary independent from being encroached by other two organs of the constitution. And why in a country like India, where the people are very fascinated with the ideologies of politicians, India, where we are fascinated by ideologies of politicians, it is very essential and important that Indian judiciary is kept independent. So the case law for our discussion that why Indian judiciary needs to be independent is Keshav Singh versus Union of India. Keshav Singh versus Union of India, very interesting case. Facts of the case are also very interesting. 7-judge judgment of Supreme Court, 1964. Keshav Singh versus Union of India, 1964. 7 judges, the judgment given by Supreme Court. Facts of the case are very interesting. Kindly be totally in ears to understand what exactly are the facts. Keshav Singh was a resident of Uttar Pradesh, and this Keshav Singh, it was alleged by the Legislative Assembly of Uttar Pradesh that Keshav Singh has committed a crime, has committed a contempt of the Legislative Assembly. Therefore, he should be brought before the legislature. As you know, that contempt can be of judiciary. Contempt likewise can also be of the Parliament of the Legislative Assembly. It was alleged that Keshav Singh has committed contempt of the Legislative Assembly. Therefore, he should be brought to answer, and then after answering, he was put to jail by the Legislative Assembly of Uttar Pradesh. Then this Keshav Singh, when was in jail, he filed a habeas corpus petition along with bail application in the Allahabad High Court of Uttar Pradesh. That petition of Keshav Singh was filed by his lawyer, got listed before the 2 judges of Allahabad High Court, and the 2 judges, they granted bail to Keshav Singh. So bail was granted, but that aggravated, that antagonized the Legislative Assembly, and the Speaker further passed the order that now not only Keshav Singh, but the lawyer of Keshav Singh and the 2 High Court judges, all these 4 people should be put behind the bar. All the 4 people have committed contempt of Uttar Pradesh Legislative Assembly. The first time the question arose whether the judges can commit contempt of Legislative Assembly in discharging their judicial function, whether judges are answerable to the Parliament, whether there is independent judiciary, whether the judges can perform in an independent manner was the question. And 7 judges unanimously of Supreme Court in Keshav Singh's case held that yes, in India we have independent judiciary. In India, judges for their judicial conduct are not answerable to the Parliament. On the contrary, the Parliament is always answerable to the judiciary. Judges, kindly listen to me properly, judges are not answerable to the Parliament for their judicial conduct, but any parliamentarian for his conduct as a parliamentarian is always answerable to the judiciary. I will give you an example of this. This case concludes that in India we have independent judiciary, judges are not answerable to the Parliament, but parliamentarians are answerable to judiciary. In Pune, in Maharashtra, in Pune, where I live, that Lok Sabha constituency was earlier represented by Mr. Suresh Kalmadi. Suresh Kalmadi was elected Lok Sabha representative from my constituency in Pune. There was an allegation that he has siphoned a lot of amount, and conspiracy and anti-corruption raids were conducted, and therefore because of misuse and malpractices and economic offences were registered against Suresh Kalmadi in the Commonwealth Games. He was also put behind bars and was lodged into Tihar jail. Now Suresh Kalmadi filed various representations before the Delhi High Court. Many bail applications were filed, but all these bail applications were ultimately dismissed. Then his lawyer, I think, who had been a wise guy, he very wittily and in a very wise manner, or in a very cunning manner, I must say, he drafted a very novel petition before Delhi High Court for bail. In that he said that numerous bail petitions of my client are being rejected, but new contentions are raised in this bail application. My client, Mr. Kalmadi, happens to be a representative of people. He is an elected member. He being behind the bars, the voice of the people whom he is representing is being suppressed. The electorate's voice is being suppressed because he is behind the bars. He is not able to represent them. Kindly grant him bail so that he can be present in the Lok Sabha and can raise questions and issues for the benefit of his constituency people. He does not want bail for himself, but he wants bail to represent his constituency people, was his lawyer's contention. The judge was very smart. Rajiv Sahai and law. Friends, we all read judgments of various judges, but if you are in habit of reading good judgments, kindly refer to judgments of Rajiv Sahai and law. His name is Rajiv Sahai and law, before whom this case of Kalmadi came up. And this judge was very witty, very wise, very well read, and he said, okay, if Mr. Kalmadi is now very much willing that he wants to represent his people and now he being behind bars is unable to represent the people, we will now call upon the Speaker of Lok Sabha to answer to us that how many sessions earlier Mr. Kalmadi has attended, how many times he had raised questions as to his constituency people, and then taking into consideration, we will consider his bail application. All the records of the parliament were called in. After reading the record, judge said that looking into the past conduct of your client, I don't think that on this count he should be granted bail. Bail was denied. So how a parliamentarian behaves in the parliament, how his conduct is there in the parliament can always be a part of judicial scrutiny. On the contrary, judges' conduct can never be part of scrutiny. Judges' conduct can never be part of scrutiny by the parliament except in impeachment proceedings. Friends, many lawyers nowadays are interested in appearing for judicial examinations. Appearing for judicial examinations, taking into consideration the increased number of seats, has now become easy also. A lot of availability in seats is there. Many candidates also get selected. But as a lawyer, a question may arise in our mind. How are judges of High Court and Supreme Court appointed? We know how a judicial magistrate is appointed. Law minister issues a notification. There is a written prelim exam, written exam that we call mains exam. Then there is a oral exam. Then at Uttan there is a judicial training, and you become judicial magistrates. But the question may arise in minds of lawyers that how are judges of High Court and Supreme Court appointed, and what mechanism should be followed in appointing judges of High Court and Supreme Court. After my lecture ends, and after the end, friends, kindly note down the name. The name is Behrul Islam. Behrul Islam. Behrul Islam was why appointment of High Court and Supreme Court judges is always a hot cake issue. The reason is how these people are appointed as judges. Behrul Islam, he was a sitting member of Rajya Sabha from Assam. He resigned from his term of Rajya Sabha as a member of parliament, and he got elevated as High Court judge in Assam. He completed his tenure as High Court judge, and he could not get elevated. He could not get elevated as Supreme Court judge. He retired as a High Court judge. Then he was again he contested elections of Lok Sabha. He could not win elections of Lok Sabha. After the elections of Lok Sabha, he was directly elevated as the judge of Supreme Court. Behrul Islam was directly elevated as judge of Supreme Court. Even before he could complete his tenure as Supreme Court judge, that is 65 years of age limit, he again resigned as a Supreme Court judge and contested Lok Sabha elections. He again lost the elections. So, Supreme Court judge resigns and contests Lok Sabha elections. Again is lost, and that party again enrolled him as a Rajya Sabha member of parliament. These kind of people, they should not be appointed as judges. So always there was an issue that how the mechanism of appointing High Court and Supreme Court judges should be kept out of the hands. The appointment of High Court and Supreme Court judges should be kept aloof from the executive was always a question in discussion. And today, as on date also, there is no clarity as to how Supreme Court and High Court judges are appointed. High Court and Supreme Court judges, if you open the Constitution, Article 124 of the Constitution says Article 124 says that the President of India, in consultation with the Chief Justice of India, shall appoint any person to be High Court or Supreme Court judge. This word in consultation, President in consultation with Chief Justice of India, these words in consultation, there was a scope of interpretation, there was a confusion, there was a dilemma, not amongst the minds of the executives, but also inter se the judges of Supreme Court. Supreme Court also did not have a clarity what exactly the words in consultation mean. Words in consultation, whether they mean that, like take an example which I usually give, that in any Indian house, a typical middle class Indian household, if you are having say a daughter of some 14 or 15 years, and she is asking her father that now it is night 9 o'clock and I want to go out, and father may either say yes or no. That asking by the girl and that telling by the father is having a determinative value. If the father says yes, then she will go. If father says no, she will not. And take another example. If the same father who is around age of 60 or say 50 years and he asks his own aged mother about some household things, about some permission as to the house, and the aged mother of some 80 to 90 years is asked by her son of 50 years some permission, then that permission, friends, is a mere formality. Whatever that son aged 50 years is bound to do, he will do. So whether the term in consultation, who has the decisive role, whether the president's verdict is the ultimate verdict or whether the chief justice's verdict, his opinion is the ultimate opinion, was an issue since the inception of the constitution. Three case laws are very important in this behalf: how judges of High Court and Supreme Court are appointed, and how there was change in view from in the Supreme Court inter se in last 30 years. Basically, it started with the case of S.P. Gupta versus the Union of India, when Chief Justice Bhagwati was the Chief Justice of India. In that, Chief Justice Bhagwati said that whenever the President consults with the Chief Justice of India to appoint any person as High Court or Supreme Court judge, that consultation is mere formality. Consulting with the Chief Justice is a formality. Chief Justice does not have any decisive vote. The opinion of the Chief Justice is not binding upon the President, and that was the contention in S.P. Gupta versus Union of India, Constitution Bench judgment. This continued for 10 years, and then ultimately after 10 years, Supreme Court's advocate on record versus Union of India, 1993, Supreme Court changed its view. It saw that people like Behrool Islam are getting appointed and there is interference of executives in appointing the judicial members. Therefore, Supreme Court had to change its view, and Supreme Court said after a span of 10 years, in the case of Supreme Court's advocate on record, 1993, that the appointment of the judges of Supreme Court, the in consultation procedure with the Chief Justice is not a formality. Chief Justice has veto power. The verdict of Chief Justice is the final verdict. Consultation with the President is mere formality. Consultation with the President is formality. That was a very diagonally opposite view taken by Supreme Court. S.P. Gupta Supreme Court said that the consultation procedure, the President has the ultimate verdict. President into bracket Prime Minister has the ultimate verdict. In Supreme Court's advocate on record versus Union of India, Supreme Court said that the opinion of the Chief Justice carries the ultimate finality. But friends, these two were the extreme views. And Lord Acton says, if you have read jurisprudence, Lord Acton very wisely says that the power has a basic characteristic feature. Power corrupts, and absolute power tends to corrupt absolutely. Here there was absolute power in the case of S.P. Gupta with the Prime Minister, and in the case of Supreme Court's advocate on record, the power was with the Chief Justice alone. In both the cases, there was concentration of power, and whenever there is concentration of power, there is a chance that the power will be misused, is Lord Acton what he says, and therefore there was a need of some third judgment, and therefore there was a need to find some golden mean. Friends, in India, we Indian people are in habit of following golden mean. Gautam Buddha and Vivekananda also say the same. Out of the extreme paths, we Indian always choose. We are neither extremist, neither we are too submissive, we are moderate. Even if you take into consideration our economic system, we are not capitalist, we are not socialist, we are mixed economy. In India, jokingly it is said that our Rashtrapati Bhavan is exactly between the 10 Downing Street of England and the White House of America. We are neither unitary, the government form is neither unitary nor federal, we are quasi-federal. So extremity is not what we Indians go with. There was a need of some golden mean, and therefore there was the third judgment which we are following today also. Appointments in India as to High Court and Supreme Court judges are made as per the third judgment, which I am going to tell. That is Special Reference 1998. Special Reference 1998 was a reference asked by the President to the Supreme Court, and Supreme Court clarified that in India there should not be concentration of power in appointing the High Court and Supreme Court judges. Neither the President nor the Chief Justice alone should have the ultimate veto. But in India we have a collegium system. Collegium system evolved in Special Reference 1998, whereby the first 5 senior most judges of Supreme Court, they are the people who appoint High Court and Supreme Court judges. Chief Justice alone, opinion of Chief Justice alone, his dictate alone carries no importance. Opinion collectively given by the first 5 senior most judges of Supreme Court is what is the appointing authority as far as High Court and Supreme Court judges is concerned as of now in India. So friend, this is how appointment of High Court and Supreme Court judges is made in India. A further question, now we'll move to further topic. A further question as lawyer may arise from academic point of view in our mind, that what exactly is the relation between High Court and Supreme Court? As lawyers, we are well aware that High Court and Supreme Court both are constitutional courts in India. High Court as per Article 226 and Supreme Court as per Article 32, both are writ courts. But what is the difference, or what is the relation between High Court and Supreme Court in India? And that was pronounced in a very historic judgment, a landmark judgment by Supreme Court in the case of Naresh Niraskar versus State of Maharashtra. What exactly is the relation? I mean the constitutional relation, writ relation between High Court and Supreme Court. That was an issue, that was a confusing issue which was settled by Supreme Court in the landmark historic case of Naresh Niraskar versus State of Maharashtra 1975, whereby Justice Tarpunde of Bombay High Court, he passed a judgment. I will tell you the facts of the case and I will also ask you a question. Naresh Niraskar was the petitioner, and Naresh Niraskar being the petitioner, he was dissatisfied with some of the findings and the judgment given by the High Court. So whenever you are dissatisfied by the judgments given by the High Court, ultimately you approach the Supreme Court. So whenever friends you approach the Supreme Court, either you will file a civil appeal, you will file a criminal appeal, you will file a special leave petition as per Article 136, or you can file a writ petition, Article 32 in Supreme Court. So this Naresh Niraskar, kindly listen to the facts very minutely. Naresh Niraskar was dissatisfied with some findings of the High Court, and those findings were challenged by Naresh Niraskar in Supreme Court by way of filing a writ petition under Article 32. First time the question arose whether Article 32 petition can be filed against judgment of High Court. So what would be the answer? Whether against judgment of High Court, whether we can file a Article 32 petition in Supreme Court. So friends, answer to this was already pronounced by the 7-judge bench of Supreme Court in Naresh Niraskar, whereby Supreme Court said that the relation between High Court and Supreme Court is that of a younger and elder brother. From the eyes and from the spectacle of the Constitution, both High Court and Supreme Court are equal, they are at par. Article 32 petition can be filed only when there is violation of fundamental right. High Court's order does not violate your fundamental right. that may be wrong on merits. You can challenge on merits, but not under the garb, not under the disguise that it is violating your fundamental right. Article 32 is filed only when fundamental right is violated by state. And if you check the definition of state under Article 12, you will find nowhere there is a mention of High Court and Supreme Court of Judiciary in Article 12. So High Court is not a state. Judicial orders do not violate fundamental right. And therefore, Article 32 petition cannot be filed against the order of High Court in Supreme Court. Even the writ of certiorari, we all know there are 5 types of writ: mandamus, habeas corpus, quo warranto, prohibition, and certiorari. The writ of certiorari can be exercised by High Court or Supreme Court against the lower judiciary, but not by Supreme Court against High Court. Constitutional relation between Supreme Court and High Court is that of younger and elder brother. Supreme Court cannot issue certiorari writ against the High Court. From the point of writ jurisdiction, in some cases, it was held in Naresh Miraskar case, from point of constitutional purview, constitutional perspective, High Court is more powerful than Supreme Court. But friends, in the case of Naresh Miraskar, there was a dissenting judgment of Hidayatullah, and Hidayatullah at that time said in Naresh Miraskar case that instead of bringing the High Court to the level of Supreme Court, High Court is given an inferior treatment by the Constitution. High Court is not at par with the Supreme Court. Supreme Court should not, by way of the judgment of Naresh Miraskar, elevate High Court to its own level, is what Hidayatullah in dissenting judgment said. He was of the view that High Court should be given the treatment to which the Constitution initially has given it, because when Babasaheb Ambedkar was asked the question that Ambedkar ji, now you have framed the Constitution, and out of all the articles of the Constitution, which is the most dear article to you? Which is the article you like the most? And Ambedkar said Article 32. Article 32 is the soul of the Constitution, is what Ambedkar said. And same Hidayatullah pointed out, look, the father of the Constitution also says that Article 32 is what is the soul of the Constitution. We should not elevate High Court to the level of the Supreme Court, but that was his minority dissenting view. And in today's scenario, High Court and Supreme Court, as far as writ jurisdiction is concerned, are at par, and therefore Naresh Miraskar judgment was coming in the way of Supreme Court when Supreme Court wanted to get hold of Justice Karnan. We all know Justice Karnan, who was judge of Calcutta High Court, committed contempt of Supreme Court. Supreme Court initiated contempt proceedings, but Supreme Court could not get hold of Justice Karnan because Naresh Miraskar judgment was coming in the way. Supreme Court could not exercise writ of certiorari, writ of contempt against the issue of contempt against Karnan because of the judgment of Naresh Miraskar. Friends, leaving aside that topic, next topic now will come to. As you all know that at many places, lawyers, they go on strike. In Pune and in Kolhapur, lawyers and advocates, they usually go on strike, and they mean the reason for the strike is that we want High Court bench to be constituted, to be established at our place. Therefore, lawyers, they go on strike. I usually ask a question to the lawyers who are willing, proposing to become judges, that if you give the judicial examination, if you become judicial magistrate, and if you are posted, I am asking this question to all of you, kindly answer me. If all the lawyers who intend are willing to become judges, if you give the examination and you become judges, after becoming judge, you are posted either in Pune or in Kolhapur, and then I, as a lawyer, I appear before you and I tell you that, look, I am ready with the case. My clients are also sitting behind. They are also given proper material instructions to me. So I am ready, but I am filing this adjournment letter, is what I tell the judge. I am filing this adjournment letter. There is a strike called upon, and taking into consideration this strike of the lawyers, which the lawyers have called upon, I am unable to function. Kindly adjourn today's matter. So friends, what will you do? I am ready with the case. Judge is ready. Case is called upon the court, but I file an adjournment letter and I say that because of strike, the matter should be adjourned. Many a times what I have found is that in open audience, the audience, they raise their hand and they say that yes, we will adjourn the matter. That is a mistake. Friends, you should always remember, when you are working as a judicial magistrate or when you are working as an advocate in the court, that lawyers are officers of the court. They are not mouthpiece or organs of the client. Supreme Court has said in the landmark judgment that lawyers going on strike is illegal, unconstitutional, unethical. The judgment is Raman Services versus Subhash Kapoor. Raman Services versus Subhash Kapoor. Supreme Court clearly said lawyers cannot go on strike. Legal profession is a noble profession. Lawyers going on strike is unethical, illegal, unconstitutional. In India, we have independent judiciary. Lawyers going on strike, they put the independent judiciary to threat. They are taking over, or they are hijacking or abducting the judiciary in order to get their demands satisfied. Therefore, rule of law and independent judiciary gets violated by lawyers going on strike. In India, we have, as per Husainara Khatun's case, the right, fundamental right as to speedy justice. Lawyers going on strike and adjourning the case, speedy justice is affected. Apart from that, Article 22 says that it is right of every accused to be represented in the court. That fundamental rights gets affected. Therefore, lawyer going on strike is illegal, unconstitutional, unethical. If any lawyer goes on strike, it is the duty and responsibility of the Bar Association to take action, Bar Council to take action, and if you are a judicial magistrate, if you are a judge working in any court in India, this landmark judgment of Raman Services versus Subhash Kapoor, you should always keep in mind that the judges of Supreme Court have said that any magistrate adjourning a matter on the count of strike is committing contempt of Supreme Court. यहाँ आपने एडजॉर्नमेंट के लेटर पे साइन कर दी, तो सुप्रीम कोर्ट ने आपके रेजिग्नेशन के लेटर पे, आपकी बर्खास्ती के लेटर पे सिग्नेचर कर दी, या आप समझ लो एडजॉर्निंग मैटर ऑन द ग्राउंड ऑफ स्ट्राइक इज डायरेक्टली कमिटिंग कंटेम्प्ट ऑफ सुप्रीम कोर्ट. रामन सर्विसेज वर्सेस सुभाष कपूर. Friends, in India, the Indian Supreme Court, which is at the epitome, at the tip of the pyramid, is the highest court in India. Indian Supreme Court has various jurisdictions. The Indian Supreme Court is the highest criminal court, highest civil court, highest constitutional court, the highest court of equity. Indian Supreme Court has various jurisdictions. It has interstate transfer jurisdiction, that is original jurisdiction. If there is dispute between Maharashtra and Karnataka, that the province of if there is a dispute regarding any village like Belgaum, whether Belgaum falls in Maharashtra or is in Karnataka, that suit can be initially instituted as an original court in Supreme Court. So it is a court of civil court of original jurisdiction. Distribution of waters of the river, Supreme Court happens to be the original court having original jurisdiction. Only one jurisdiction Indian Supreme Court does not have. Indian Supreme Court has plethora of jurisdictions: highest civil, highest criminal, highest constitutional, highest writ, highest equity court, highest court as to civil court. It is the court of original jurisdiction, transfer jurisdiction. Supreme Court has numerous jurisdiction. One jurisdiction Supreme Court does not have, and that is Supreme Court is not the court of original criminal jurisdiction. The index landmark case in this behalf, why Supreme Court is not court of original jurisdiction, that was pronounced and propounded by Supreme Court in the landmark case of V.C. Mishra versus Union of India. Friends, facts of the case are very interesting. V.C. Mishra, he was the chairman of Bar Council of India, and he was arguing a case before Supreme Court. And Supreme Court found that arguments of V.C. Mishra are a bit arrogant. And therefore, Supreme Court judges, they stopped him, they prevented him from further arguing. And Supreme Court said that Mr. Mishra, we feel that you are arguing under the disguise or under the garb of being the president of Bar Council of India. Hereby, we feel you are a bit arrogant. we stop your argument and hereby we initiate contempt proceedings. Bar Council of India chairman arguing was prevented, contempt proceedings were initiated by Supreme Court. Until this, there was no doubt. Supreme Court had the authority, had the power. What Supreme Court further did became the point of discussion, became the point of criticism, and became the point where Supreme Court had to rectify itself. Supreme Court judges said that Mr. Mishra, VC Mishra, now while leaving the court hall, kindly take off your coat and gown. Henceforth, you are not a lawyer in itself. We hereby take away your sanat. Supreme Court initiated contempt. Contempt, Article 129, happens to be the inherent power of any court of record that Supreme Court was possessing, no doubt. But whether Supreme Court can, at the very instant first stage, take away the sanad of the lawyer was the question in discussion. And in VC Mishra, Supreme Court had taken away the sanad of that lawyer arguing before itself, and then we people of Supreme Court Bar Association, we got antagonized, we got afraid that whether a junior like us is arguing a case and by mistake speaks something out of the mind, then he also will have to go off with his sanad. And therefore the Supreme Court filed a petition in Supreme Court, that is Supreme Court Bar Association versus Union of India, whether Supreme Court has the authority to take away the sanad at the first instance was the question. And Supreme Court, as I earlier said, Supreme Court said, as Supreme Court has always clarified, that Supreme Court cures, rectifies its mistake, and in this case also Supreme Court rectified and cured its mistake, and Supreme Court accepted that yes, Supreme Court does not have the jurisdiction to take away sanad of the lawyer in its original jurisdiction. In appellate jurisdiction, as per the Advocates Act, Section 38, in appeal against the Bar Council of India, Supreme Court can take away, suspend the sanad of the lawyer, but originally Supreme Court at first instance cannot act as a court of original, as a court having original criminal jurisdiction. Taking or giving a sanad to a lawyer has features of criminal trial. Taking away sanad of the lawyer has features of criminal trial, and we all know, as per the Indian criminal jurisprudence, the criminal trial, it proceeds in a certain specified manner. In criminal trial, there has to be accused, there has to be allegation, there has to be accusation has to be tried, there should be an opportunity given, then the accused is given an equal opportunity to have his own witnesses, his own documents, and then after reasonable hearing and proving beyond reasonable doubts, accused becomes convict in India as per the Indian criminal jurisprudence. And this concept, this phenomenon, this trial procedure is the incapacity of Supreme Court. Supreme Court has all the jurisdictions, but Supreme Court cannot be the court of original criminal jurisdiction. Supreme Court has all jurisdictions, but Supreme Court is not the court of original criminal jurisdiction, is what was said by Supreme Court in this landmark judgment. Friends, I have numerous cases to discuss, but I think the time is running out. It is 6:15 already. I don't know whether I should continue or I should stop, because my potential which I am having as on now is of 1 hour more, but I was told that I should stop within an hour's time. But I will just conclude by a few more judgments of Supreme Court. A very interesting judgment I will tell you. I have many judgments to tell, but to end our lecture, I will be ending with a very absurd judgment. Friends, Supreme Court is having all jurisdictions, as I told. You all know that there is a doctrine of res judicata. What is res judicata? Section 11 of CPC says that res judicata means the same court between the same parties, once decides the dispute, it becomes functus in officio. In English era, the English judges, after giving the judgment, after signing, when the English judges at the English era, after giving the judgment, when they used to sign, they used to break the pen's nib. They used to break the pen itself after signing. The nib of the pen, they used to break it because they used to say that after signing, we have become functus in officio. Even after going home, we come to the conclusion that the judgment was pronounced in a wrong manner, or if our views they change, now we will not be in a position to correct our views. That is the doctrine of res judicata. Two parties, two or more parties, same subject matter. Once the dispute has been decided, court becomes punctus in officio. It is unable to decide upon the same issue against, and that is in fact a beneficial doctrine to give certainty, finality, assurance as to justice. Res judicata is brought into the books. You will be astonished to know, friends, Supreme Court of India is the only court which is not bound by the doctrine of res judicata. Same two brothers, same 2 acres of land, same decision given by the Supreme Court. Supreme Court can again reshuffle, unshuffle, unfold the judgment, and Supreme Court is not bound by doctrine of res judicata. Supreme Court is not bound by any procedural doctrine. It is also said Supreme Court's philosophy is ex debito justiti. While doing substantive justice, procedural law should not be a hurdle. Supreme Court is not only the highest constitutional, highest civil, criminal, but it is the highest equity court in India. Whenever Supreme Court feels that even though we have pronounced the judgment that has attained finality, but still in the same very judgment by way of review petition, even after the review petition has now elapsed, even after the Supreme Court's review petition has elapsed, Supreme Court can, by way of curative petition, interfere in the case, and Supreme Court can reshuffle its own judgment. So Supreme Court is not bound by doctrine of res judicata. Supreme Court is bound only by the doctrine of ex debito justiti. It is the highest equity court in doing substantive justice, a procedural law, civil procedural law, and a doctrine like res judicata cannot come in between, cannot act as a hindrance, cannot be a limitation for Supreme Court in doing justice. Supreme Court is not bound by any procedural formality. Supreme Court, being the highest court in India, is bound only by equitable principles. Whenever there is grave violation of fundamental rights, even in the same specified case, Supreme Court can unshuffle, unfold, and Supreme Court can rectify its own judgment. Res judicata not applicable to Supreme Court, only court in India where this doctrine is not applicable. Friends, there are many cases, numerous cases which I can tell, but taking into consideration the time limit and time constraint, I would just end up with one very hilarious case. Hello? Shraddha ji bola. One interesting case whereby I will be stopping my lecture, P.V. Narasimha Rao versus CBI. Friends, we all know that P.V. Narasimha Rao was the Prime Minister of India, and he also had to go and land up at Tihar jail, where Lord Krishna was born. Krishna was born in jail, and many Indian politicians had to ultimately visit some of the other time this jail facilities they had to experience. And this P.V. Narasimha Rao, ex-Prime Minister, also was not an exception to this. When P.V. Narasimha Rao was the Prime Minister, the case which poses a very hilarious count, or the case which poses an absurd judgment of Supreme Court, that is the P.V. Narasimha Rao versus CBI. P.V. Narasimha Rao, ex-Prime Minister, was put in Tihar. He was put in Tihar because his government was not having sufficient majority, not having sufficient support of members of parliaments in the Lok Sabha, and therefore 14 member of parliaments was the need of P.V. Narasimha Rao. He was in need of 14 member of parliament. So you all know how the members of parliaments are, how their support is to be gained, and the horse trading or buying and selling of this member of parliament started at that time, and this whole of this conspiracy was put to light by CBI, and because of which P.V. Narasimha Rao had to also go to jail. So 14 member of parliaments was the lacuna. P.V. Narasimha Rao wanted to purchase them. So there was a lobby of some member of parliament, some MLAs, member of legislative assembly, and some businessmen. They collected the money and they wanted to buy 14 members of parliament. So there were three types of members of parliament. One who gave money, one who took the money and voted in favor of Narasimha Rao, and few who took the money but did not cast any vote. They abstained from voting. Again, I will clarify. Narasimha Rao,
wanted to purchase 14 members of parliament. This whole conspiracy was brought in light by CBI, because of which Narsimha Rao was arrested and was lodged into Tihar jail. Narsimha Rao manipulated his members of parliament, got money, and his members, they gave money to the 14 people. So parliamentarians giving money, parliamentarians taking the money, and parliamentarians took the money and voted, and some took the money but did not vote at all. Three kinds of members of parliament. So ultimately, it was held by Supreme Court that those who gave money are accused; they should be put behind the bars. Those who took money but did not vote, they are also accused; they will be put behind the bars. But those who took money and who gave the vote, they all were acquitted or discharged, because Article 105 of the Constitution says whatever is said, whatever is spoken, whatever speech is given, and whatever vote is casted on the floor of the parliament, that cannot be a part of inquiry, that cannot be part of judicial inquiry, that cannot be questioned in any courts. So when they had voted, whether they had voted by taking money or whether they had voted genuinely, this cannot be part of judicial proceedings. Therefore, those members of parliaments who took the money and who voted, they got the immunity, they were discharged, they were acquitted, and those who gave money were put behind bars. Those who took money but did not vote, they did not vote, so they did not gain any immunity, they were also put behind bars. Who took money, who were true to the salt to which they ate, who took money, who voted, friends, they were acquitted, they were discharged. And this reminds me what Robert Jackson, the Supreme Court judge of United Kingdom's 1953, Robert Jackson, Allen versus Brown, the name of the case. Robert Jackson very wisely says about the Supreme Court of United States of America. Robert Jackson says, he was the judge of Supreme Court of United States of America. Robert Jackson says that we are not supreme. Listen properly, minutely. We are not supreme because we are infallible. We are infallible because we are supreme. हमें सब आता है, हम सर्वज्ञानी है, ब्रह्मज्ञानी है, इसलिए हमें सुप्रीम कोर्ट का जज बनाया है। ये गलतफहमी में आप मत रहिए, इस गलतफहमी में आप मत रहिए। अब हम सुप्रीम कोर्ट के जज हैं, इस कुर्सी पे आके बैठे हुए हैं, हमारी गलती निकालने के लिए कोई ऊपर का कोर्ट नहीं है, इसलिए हमारा वाक्य ब्रह्म वाक्य है, ये आप जान लीजिए। We are not supreme because we are infallible. We are infallible because we are supreme. And further, Allen versus Brown, Robert Jackson says, had there been a super Supreme Court, many of the judgments of today's Supreme Court would have been set aside, would have been overruled. Friends, there are numerous cases which can be told about Indian Constitution. It is just like a vast ocean. Many hours they fall short, many cases they fall short. In the limited duration, I have tried my best to give interesting cases to you. I would like to end my today's conversation with an exhortation. Exhortation, there are various figures of speech. Figure of speech is that when I say, that is a narration. I may narrate, I may suggest, I may request, and I may exhort. Exhortation is I am telling you with some expectation. Telling with some expectation is exhortation. And I will tell you an exhortation. A live conversation between Churchill and Nehru. Churchill was the Prime Minister of the oldest democracy, United Kingdom. When Nyaneshwara in 12th century was writing Nyaneshwari and Alauddin Khilji invaded India, that time the people of United Kingdoms, they were giving votes. That time parliamentary system was followed in United Kingdom's oldest democracy. And India is the largest democracy. So Nehru was the Prime Minister of the largest and Churchill was the Prime Minister of the oldest. Both were barristers, both were lawyers, both were educated, both were Prime Ministers and both were sitting in front of each other. Now Nehru did a mistake which he should not have done as far as Churchill was concerned. Churchill was known to be a very witty and a very egoistic politician. Churchill, it is told about Churchill that he was so witty, once he was sitting in the parliament and he closed his eyes and a lady member of parliament was arguing something was speaking something and she got annoyed. She said, "Look, I am speaking on such an important topic and our Prime Minister is sleeping. He does not have the courtesy to listen to what I am saying." So Churchill very wisely and cunningly opened one of the eyes and he said, Madam, I am not sleeping, but I feel that instead of listening to such a boredom speech, why I did not fall asleep." That lady got annoyed. And she said, if my husband was like Churchill, I would have had given him a glass of poison. Churchill very wittily said, "Madam, if you would have been my wife, I would have very happily drank the poison." So that was the wit of Churchill. And Nehru, he said to Churchill that, "Mr. Churchill, in a mature country like United Kingdom, you don't have a written constitution. Look, in India, we have given to our Indians a very well drafted constitution, and in UK you don't have even constitution itself. And in India we have fundamental rights, we have independent judiciary, written constitution, well drafted one, and you boast that you happen to be the pioneers of preserving liberties," is what Nehru said to Churchill. Churchill, friends, very wisely answered Nehru. Churchill said, "Look, Mr. Nehru, in a mature country like United Kingdoms, we, the citizens of United Kingdoms, we follow the law out of affection. We do not follow the law because it is stated, it is noted, it is engulfed in some book like Constitution. We follow the law out of affection. We follow the law because law and affinity for the law is in the blood of the citizens of United Kingdom." To this, Nehru was speechless, and Ambedkar also rightly says that a good constitution in the hands of bad people is useless. A bad constitution in the hands of good people is a fruitful, useful document. There is a constitution in Israel, there is a constitution in Afghanistan, but that constitution is only namesake constitution. In United Kingdoms, they don't have a constitution. Still, it is known to preserve, protect, and to safeguard the liberties and the rights of the citizens. What is necessary, friends, which all of us, including you and me, should keep in our minds, is not what book says is not important. What actually we practice is important. To preserve the rights should be in our bloods, and that should not be because it is dictated, written in some constitutional book. Friends, there are many more cases, many more narrations which I can tell, but taking into consideration the time constraint and the limitation, I better feel that I should stop because it has been more than an hour I am speaking, and the time is 6:30. I started at 5:10 or 5:15 something. Time allotted was not more than an hour to me. I stopped the lecture and let's start with the question and answer session. Thank you, friends. Thank you.